Any mention? May it please your lordship?
Yes.
Lordship, I beg to make a mention of item number 10, your lordship.
Item 10.
Yes, your lordship. Lordship, I pray this matter may be listed after vacation, your lordship.
Yes.
No objection, your lordship.
As requested by the Honourable Counsel of the petitioner. Justice matter provocation.
Highly obliged, your lordship. May I please your lordship? Your lordship, I beg to mention item number 7, your lordship. I've taken the consent from the other side. May it come
No
after
objection.
vacation, your lordship.
No objection. Same. Yes.
Lordship, similar prayer for item number 8 also, your lordship.
Who is there on the other side?
I'm there.
No objection. Yes, that is okay. You are there for the private respondent. For respondent number 4. Just no respondent. Yes.
Highly obliged, your lordship.
Please, Lordship.
Yes.
Lordship, I beg to make a mention of item 4. Item number 4, Your Lordship.
Item 4.
Lordship.
Yes.
Lordship, I'm praying for accommodation, Your Lordship, in this matter, Your Lordship.
No objection. Yes. When?
After vacation, Your Lordship.
After vacation is little accommodation.
Lordship.
Then what will be big accommodation? Just say. Yes. Any objection?
I have no objection, Lordship.
There is no interim order in this matter.
No interim order.
So same. Yes.
Lordship,
After vacation. Yes.
Lordship, item 9, Your Lordship. Item 9 as well, Your Lordship.
Item
Item 9.
9.
Lordship,
Yes.
this is legally matter, Your Lordship.
Yeah.
And similar matter is pending before the division bench of this honorable court.
This is also same order.
Same.
You just say, write down his name, Learned Counsel, appearing on behalf of Ardatta Learned Counsel. Praise for adjournment for the matter.
Lordship.
Here also you are there, Mr. Kanu.
In this case, Mr. Sengupta is there. He's in
So anyway,
courtroom number 2.
so now we can record your name for this.
Yes, Lordship.
Yes, Mr. Kami appearing for this.
And it's the matter
No objection.
in which the similar issue is pending before DB.
Prayer is allowed. List after vacation. Yes.
Obliged, Lordship. Lordship, item 11. Lordship, I'm a proxy counsel in this matter, Your Lordship. Item 11, Your Lordship. Lordship, I'm a proxy counsel in this matter, Your Lordship. I'm a proxy counsel in this matter, Your Lordship. Miss O Bang is the conducting counsel, Your Lordship.
There also you want it after vacation?
Lordship, a week, Your Lordship.
For a week?
Lordship. I think here the issue
There
is also
if
the
you
same.
want adjournment, it will go after vacation. There also is Mr. Sancho, Learned Counsel appearing on behalf of. You are appearing on registration form?
O Bang.
All that. Achha, so appearing on behalf of. Or you just say on the prayer made by so and so on behalf of MS Soibin, Learned Counsel appearing for the petitioner. This is matter after this. Yes,
Lordship, I pray for item number 6, Lordship.
Yes.
Item number 6. This matter also is question of POXO. The
So
similar issue is
depending
pending.
upon the division bench.
Pending, yes.
This also the request made by the parties. List is matter after this.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 2, Your Lordship.
Item number 2.
Yes, Your Lordship.
Yes.
I humbly pray let this matter be taken next week, Your Lordship.
Why next week? What is this matter?
Lordship, this with regard to election of Gaubara, Your Lordship.
Then it will go after vacation. If we hear matter next week also, there will be hardly any time for passing judgment. We do not know how long a matter will take. Yes, any objection?
No, Your Lordship.
This is requested by the parties. This is matter of vacation. Yes.
Highly obliged.
Similar prayer for item number 11, Your Lordship.
Item 11 is already.
Apologize, Your Lordship.
Yes.
Item number 1.
Yes.
Smarter, Your Lordship. On the last occasion, the mega submission there was some amicable solution, but however, Your Lordship, they have given this one letter that dated 19 September 2024, Your Lordship. I just have placed it. Actually, this is the outcome of the button. Your Lordship, we are still not satisfied. Just this is the main case here is for non-implementation of PPA Commission, where the GHD is respondent.
Wait.
Lordship.
Let us just.
Let's.
Hold on. No, what is this and what does it mean?
Now, what happened in this case, Your Lordship?
That order is passed in suppression of the office order dated 43. What was the office order 43?
That office order we have not given a copy.
So how do we understand what is this?
Yes, now what I'm trying to state, what as per the instruction from the petitioner hearing is this PPA commission JHDC have approved. It is there in the record. They have approved to
Has it
agree.
been notified?
It's notify and then they
please-
notify in the
What
sense
is the
that-
notification?
no, there actually lordship there is no notification for me. I just you
May
take
I please submit, Your Lordship? Your
page
Lordship,
poll.
with regard to letter supplied by the petitioner, Your Lordship, we have sent a letter for instruction, Your Lordship. We need some more time, Your Lordship, regarding this letter.
No, this says that
I humbly pray, Your Lordship, 2 weeks time, Your
no,
Lordship.
it's an order which says that payment of salary of 1 month as per recommendation of Meghalaya paper.
That's why, Your Lordship, we
Now
need
this
some
order is
instruction.
basically confined to payment of 1 month salary.
Yes.
Now it is which month salary?
For that, Your Lordship, we
yes,
need some
that's why
This is
instruction,
1
Your
month
Lordship.
salary, whether it is a salary of September or October or which month.
They have not specified any date.
Then definitely this order would have no bearing
Yes,
after the
that's
1
why,
month is over.
Lordship, that's why we said that we are not happy with this and we want to pursue with the case. The thing is, it seems that this letter and another letter also is partly implementing. They are not denying. They said that they have approved in the various meeting, but the executive committee has approved even the PPA commission, and they said that we will implement the PPA commission and will implement it. That approval, kindly have a page 16 of my repetition. That is their approval, and thereafter it is a legal expectation of the petitioner that the approval letter issue on 19 March 2018 will be implemented. That's why, since on the basis of the order, may I just have a take you to Lordship to the page
Your
16.
Lordship, I
Page
humbly
16.
submit, Your Lordship. Let this matter be
We
taken
can
up
get
for 2 weeks,
instruction,
Your
but I
Lordship.
just wanted to brief to the court so that court will have the gist of the case.
This petitioner number 2 has been terminated from service.
No, he resigned.
number one
Yes,
has resigned.
terminated, but he was already there was an order. His termination also was caused by the other bench. Now they have filed appeal against the order of the single bench. Now order, yes, the appeal is still pending, and we have also filed the contempt against the JCD's respondent for non-compliance of the order, where it says to reinstate. There was an order from the court.
His termination has been interfered by the court.
Yes, Lordship, actually. Then against the order of the single bench, interference of that, they have filed the appeal. Appeal still it is only for some hearing is there.
There is no interim order.
No interim order. And we have filed the contempt also. Contempt issue have been issued. They have not. They supposed to file in APTP.
And what number 1?
Number 1, actually, he has resigned, Your Lordship.
So then how can he maintain this case?
No. To that effect, there is another order was there, Your Lordship, because that one has been substituted. We have filed from this court only. We have filed the substitution
What
order.
is that order?
That order is there, Lordship. Somewhere that order is there, Lordship.
Somewhere it is there.
No.
Where?
It is there from this court only. But I executed. To that effect, we have filed an application to replace. This court has considered that order. Spared. The terms this court person shown by agent and who is one of the by several statement made order order 19/12/2023 also is there, Lordship. But one we have filed a specific one application where court has
19/12/2013.
yes, Lordship. One order is there.
No, whether this petitioner number 1 name was deleted from the array of parties.
Yes,
It
one
was deleted.
Yes, Lordship.
So you
This,
say that.
yes, yes. 1 and 2 has been deleted. This one,
1 and 2 have been
Lordship, it is
deleted.
order 2305/2023, Lordship. That deletion order is there, Lordship.
23?
2305/2023.
What is the division bench judgment?
Division bench. There is no division bench, Lordship.
No, there is a division bench judgment which was referred probably in this matter case. Was it by you or by the respondent? No, not by you.
Not by me, Lordship. I am not aware of the division bench.
Yes.
Now, what happened, my lord? This PPA commission was approved on 19th March 2018, your lordship, by the executive committee in this order, where it says, may I just read it? The executive committee government council Tura is pleased to approve page 16, my lord. 16 annexure number 1.
Yes.
It says that executive committee Garo Hills Autonomous District Council Tura is pleased to approve and endorse the Meghalaya government resolution on the PIP on the recommendation of the PIP Meghalaya Pay Commission White number dated Shillong 28 November 2017, with each making applicable for implementation of the PIP Meghalaya Pay Commission in JCDC with effect from 01/01/2017. They have stated with effect from 01 January 2017. All departments are hereby directed to prepare the pay and allowance of officers and staff in new revision of pay and allowances as per provision of the Meghalaya Services revision of pay and other related rules starting from the month of April 2019. They, as per this order, Your Lordship, this approval order, they supposed to that has to come with effect from 1st January 2017, and they further directed should pay the salary and other revision or other service benefit with effect from the month of April 2019. But then since after even passing this order, been approval, they have not implemented, they have not acted upon on this this approval order till now. Now some sort of letter they have, it seems that it's like partly implementing it. That's that one letter which I've shown this 1 month, but it's not specifically mentioned for how many, for which month. Therefore,
This is an order which was passed in 2018,
Lordship,
and now and then the office order which you have furnished us just now, it is of
Online.
2024,
yes,
and that is only for 1 month.
this
It
one
means
for-
in between many things have happened.
many in between also they have enclosed another letter also, my lord.
No.
Yes, yes,
See, there is a lapse of almost 6 years time
yes.
from the order which is annexed at annexure 1 in your thing,
Yes.
and the order which you have given us now.
Yes.
Now, some development must have taken place now.
The development, my lord, as per the instruction, they have not implemented. They are still not even as of now till date. They have not implemented this order. That's why, since the letter they are not denying, they want to implement. Only thing is that they can partially. It's amount to partially implementing. Therefore, the prayer of the petitioner is to regularize the implementation of
this
the.
thing that your district council, there was a agitation against non-payment of salary and all, isn't it?
Yes, non-payment of salary and that was there.
That was there.
It's
So
a long while.
when the existing salary which is there, the district council are unable to pay. Where is the question of implementing this order then?
Your Lordship, the contention of the petitioner is whenever they pay, because GHDC they are not admittedly they are not able to, they have not in a position to pay the salary regularly. But then the contention of the petitioner is whenever they pay, maybe like after 6 months they used to pay 1 month, 2 months something, but whenever they pay,
They may not pay also. They may be unable to pay.
so whenever they pay for 1 month or
Only
2 months,
an order in contingency, and we do not know. You see, this order you are showing us, this is of 19th March 2018, and then
they
of course there is nothing. Probably that they have never implemented it.
never implemented. Never
Now,
implemented.
this is a 19th September order which you have given. That this is the decision of the executive committee to implement the pay scale for payment of salary only for 1 month. For which month?
That one is the respondent should
Yes, madam.
have
What is
answered.
this?
Your Lordship, as per this letter, we have not received any instruction, Your Lordship. So I humbly pray that this matter be taken after 2 weeks, Your Lordship.
Now, what happens to you? Have you filed an affidavit in opposition this matter?
Yes, Your
They have
Lordship,
filed
we
it.
have filed, Your Lordship.
What is their
Then
answer-
their
answer to
affidavit-
this
Because
answer?
Mr. SJ will be in a position to explain better, Your Lordship, in this matter.
In their affidavit, my lord, they are not denying that. Only the statement what they made in their affidavit is whenever the financial position is good, then they will pay as per the pay commission. That was the statement in the affidavit in opposition, my lord.
Now that means this implementation of this order.
Your Lordship, if you kindly come to our affidavit, Your Lordship.
This affidavit in opposition, yes.
Which we have filed on 14 March, Your Lordship, 2022.
Yes.
In paragraph number 8, Your Lordship. Second para, Your Lordship.
Yes.
Your Lordship, second para, it's mentioned, Your Lordship, it is pertinent to point out herein that the
Subpara.
yes, Your Lordship.
Yes.
It is pertinent to mention out herein that the petitioner have already accepted the salary for the said month without any objection and or complaint at the relevant point of time. Moreover, the petitioner have also received the respective salaries regularly as per the availability and allocation of
That
funds.
is not the issue here. The fact remains that there is an existing order passed by you. Why this order should not be implemented? That is something. That order,
Yes, Your Lordship.
that annexure 1, the writ petition,
Yes, Your Lordship.
was issued in 2018 with a date fixed here for implementing. So why that is not been done? Why that has not been done? Has this order is in existence or it was recalled?
That Mr. SD will be in a position, Your Lordship, to explain, Your Lordship.
If any such order stands, then you must implement it. You cannot pass an order for keeping it in cold storage, isn't it?
Yes, Your Lordship.
Then and you are passing this kind of orders in spite of the fact that you are having financial crunch, knowing very well what financial liability will create. Anyway, it is for you to see. But then for us, we will only see whether there exists any order or not. And if that order is subsisting, then you must implement it. Once you fix a date, why not? You take instruction on this.
Yes, Your Lordship.
Yes, Mr. Sangma, let them take
Yes,
instruction.
Lordship.
Where is Mr. Day?
As day is our station, Your Lordship, sanction leave.
Say Miss MS and Raji. Learned Council. 6. Learned Council appearing for the response number 1 to 6 adjournment of the matter on the ground of non-availability of Mr. S. Day. Non-availability of arguing counsel Mr. S. Day, who is stated to be out of station. The learned counsel of the petitioner has not objection. Praise the Lord. This is matter after vacation.
Lordship.
You take instruction.
Yes, Your Lordship.
And you also verify that. How can it be for 1 month and all those things? That order which you have given us,
Yes.
what it would mean, and it is for which month?
Because actually this
Just
respondent
try to-
authority
try
who is
to
supposed
ascertain-
to
try to ascertain if it is
yes,
possible.
yes, yes. Lordship.
Much
Much
obliged.
less Lordship.
Item number 5.
My lord, I've got very limited prayer here that the shops of my key was seized by the police and it was handed over to them. So when the time came for its release in the Jimma, I was not even heard despite my application. That is my only prayer, that it should be remanded, let the matter be heard. Of course, it is a mixture of civil and criminal case, but
Whether law says that you should be heard. The seizure was made from whom?
from me. So this is the key of my shop. At least I should be given an opportunity. And the IU report was called, and IU report says that it should not be released in the favor of anyone because there is a claim and counterclaim. Despite that, IU's report was ignored, and order was passed in their favor for release by lord. So now I only pray that why should not I be heard? Should be given an opportunity of being heard by lord. Whatever the order be passed.
No. See, in a Jimma application, did you file any application for Jimma?
Yes, my lord. I filed application for that. I should be
Then
given.
you have not been heard.
No, I was not being heard.
Then on what basis the order was passed in their favor?
Without any basis. IU's report also was not
They did not
considered.
file any application also.
No, they had filed.
Lordship, both were
They
heard.
had filed. But I was
Both of
not
us were
heard. No, my lord, IU's report says that
Page
it should not be
94
released.
Of my counter affidavit.
My lord, IU said it should not be released because there is a claim and counterclaim. That IU report was ignored.
Just come to the things. You just show us where the things. When did you file the application for release on Jimma? When it was seized? You are Vijay Singh.
Yes, my lord.
And what is this application number 20 of 2023 and 20 of 20 filed by Sri Sanjay Sharma and Sri Vijay Singh?
That was for release of the.
Then you say you have not filed any this thing.
I have filed the application, my lord. That is my case. But I was not heard. And I am saying that on the first occasion.
Court has passed order on your application.
Yes, my lord, but it was. But please come to. I will start from here. Please come to page 83, my lord. It is a legal confusion with the annexure 25, page 83, my lord. 83 and 84.
Yes.
Page 84, my lord, last paragraph.
Yes.
Your Honor, I most respectfully pray before this.
No, this is IOS report. But
Yes.
Confined to the first submission, you said you have not been heard, you have not been. That is what. But in this order says something else.
Which order you are saying, my
You
lord?
cannot make submission which is not supported by records.
My lord, 21st September is my application. Lecture 24,
Just
page 80.
come to the impugned order. Where is the impugned order? Which order you are impugning? You cannot jump from one place to another and then you say one thing and the record shows another thing.
Well, that order is at page 75, lecture 22.
Yes.
It is a very lengthy order, my lord. Only last part I will read.
So why there is a problem? You have a shortage of time.
No, my lord. So,
Please read it. We should.
my lord, record put up today before me along with other application number 2023 and 2123 filed by petitioner Sri Sanjay Sharma and Sri Vijay Singh, moved by Learned Counsel Sri R. Kharkarang and Learned Counsel Srimati M. K. Shah. The state is represented by Learned Additional PP Srimati J. Mara.
That is for sure that you were heard. Your application was filed. Somebody has moved it. Now you cannot come and say that you have not been heard. Please now proceed.
Sure.
You see.
Heard Learned Counsel for the petitioner Sri Sanjay Sharma. See, my lord, it starts from here. Heard Learned Counsel for the petitioner Sri Sanjay Sharma on application number 2023.
But then before that it says.
No, I was present, of course. I was present.
Who is Archival and M. K. Shah? They are not your counsel.
My counsel, my lord, but they were not heard.
Fine.
Presence is there, but hearing is not there.
A petition has been moved. How can it be moved without opening your mouth? Just tell us.
No, my lord, that it is an application for release of Jumma, my lord. That we said, and then they started hearing. Only one side was heard, and then.
Please proceed. Please
Lordship,
proceed.
para 7, I'm sorry to interject.
No, it's all right. Let him place his version. It's not that you see, like the court will have a mindful application. You see, this will not be a mechanical reading of the part.
Lordship.
That is for sure. Yes, please.
My lord, I am saying that IO's report was called. It was the duty of the court to look into the IO's report and then pass the order. What was the hurry?
Please proceed with the reading.
So, I am from Heard Learned Counsel for the petitioner Sri Sanjay Sharma on application number 2023, who submits as follows: that the petitioner had preferred a Jimma application of 1 number of weighing machine and 21 number of keys, and the same was allowed, and the said items were released to the custody of the petitioner by order dated 1/12/22, passed by Learned JMFC Miss R.D. K. Sangma. That agreed by the said order, the criminal division petition number 123 was preferred before the Honorable High Court, Meghalaya, and by order dated 6/1/23, the Honorable High Court was pleased to direct the court to keep possession of the keys pending disposal of the
criminal. This is the second round of litigation.
This is, yes, this is second.
You are Sanjay Sharma.
I'm Sanjay.
That the keys which were released on Jumma to the petitioner were presently in possession of this court. That the criminal division petition number 123 was disposed of by order dated 15/9/23, wherein the interim order dated 6/1/23 passed in the said criminal division was vacated. That in view of the order dated 15/9/23 in criminal division petition number 123, the order dated 1/12/23 passed Jimma application number 67/22 stands restored back and comes into effect. In the circumstances mentioned above, the Learned Counsel prays before the court to release the key back to the petitioner. Heard Learned Counsel for the petitioner Vijay Singh on application number 21/23, who submit as follows: that the bunch of the keys belonging to the petitioner's shop, that is SS Aluminium and Steel, is lying in the court Malkhana and the petitioner has filed an application for the release of the Jumma application, which is registered as Jumma application number 5323, and the petitioner is yet to be heard in the said application. That Sri Sanjay Sharma has also filed an application with regards to the said bunch of keys. In the circumstances mentioned above, the learned counsel prays both the parties are required to be heard together. Heard learned additional ABP who submits that as their petition number 2123 filed by the petitioner Sri Vijay Singh is concerned, the Jimma application number 5323 is already part heard and pending final order and disposal in the court of learned JMFC, and the DJ Kharshing herein the petition number 23 cannot be adjudicated by this court at this stage. But here, let me say one thing. The petition is one, but two courts are in session of the matter. One is CGM, another is Judicial Magistrate First Class. Heard the learned PP who submits that as far as petition number 23 filed by the petitioner Sri Vijay Singh is concerned, the Jimma application number 5323 is already part heard and pending final order and disposal in the court of learned JMFC, Srimati DG Kharshing. Hence, the petition number 21 cannot be adjudicated by this court at this stage. Learned additional PP further submits that she has no objection to the petition filed by the petitioner Sri Sanjay Sharma, as on perusal of the order dated 15/9/23 passed by the criminal revision petition number this, it is very clear that the said revision petition filed against the order dated 1/12/22 passed by the learned GFC, Ms. R.K.D. Sangma in Jimma application number 67/22 has been dismissed, and that the interim order dated 6/1/23 passed by the said criminal revision also stand vacated. On consideration of the submission advanced by the learned counsel, the court agrees that the learned additional PP that at this stage no reliefs can be granted to the petitioner Sri Vijay Singh in application number 2123, as the Jimma application number 5323 is still pending disposal before the court of JMFC, Srimati DG Kharshing. Further, while considering the application number 2023 filed by the petitioner Sri Sanjay Kumar, this court deems it fit and proper to reproduce the order dated 15/9/23 passed by the High Court of Meghalaya in criminal revision petition number 1 of 23 as it is. Mr. A. Siddiqui, Learned Senior Counsel, on instruction submits that the petitioner does not want to pursue the instant petition and desires to withdraw the same until with liberty to approach the appropriate authority for redressal of his grievances. Mr. N. Khera, Learned Counsel, appearing for respondent number 2, has no objection. The matter is stand dismissed on withdrawal with liberty as prayed for. The interim order dated 6/1/23 stand vacated. The court has also pursued interim order dated 6/1/23 passed by the above mentioned criminal revision petition, and have observed that while the said order, this court was directed to keep possession of the 21 number of keys pending final disposal of the criminal revision petition. While order dated 16/1/23 passed by this court in the instant case, this court, in compliance with the order dated 6/1/23 of the Honorable High Court, had taken possession of 21 number of keys and kept by them in the court. In the consideration of the submission advanced by the learned counsel and on perusal of the orders of the Honorable High Court, the criminal revision petition of this court agrees with the submission of the learned counsel for the petitioner as well as the learned PP, and is of the view that in the event of the order dated 15/9/23 passed in criminal revision petition, wherein interim order dated 6/1/23 stands vacated and the criminal revision petition dismissed, the order dated 1/12/22 passed in the Jimma application number 67/22 stand as it is, and hence this court is no longer required to keep possession of the 20 numbers of key, and the same should be released back. Petition number 22 is hereby allowed and disposed of, and petition number 21/23 is rejected and disposed of. Petitioner Sri Sanjay Sharma to take necessary step. So after this, my lord, but again I am coming to the same point that the IU's report was called by the Judicial Magistrate First Class. So next page is that. It's a small order, my lord. Please bear with me.
Here there is no reference of IU's report in this order.
No.
So this is what you are challenging.
Both the
So
things.
in this thing, it seems like the court has not decided anything on the claim. It's simply gone by the order passed by the High Court.
High Court, in High Court, of course,
Order was,
it was vacated. My lord, in the High Court, before your lordship, problem was that there was no application on my part for release of Jimma. That is why I had to withdraw and file it there that it may be released in my Jimma, my lord. So it speaks that it has taken, that because it was vacated, therefore automatically it should go to them. That cannot be the interpretation, my lord. But let us come to next page 79. It is by the judicial magistrate first class.
So it is a kind of rather, you see, the interpretation of High Court order by the trial court. It has not decided anything on this.
But Jumma was given, it is a decision, my lord.
That is all right. That is what this court is saying, that the court has basically not decided anything on Jimma. It is just a simple order saying that it should go to them.
To them, Jumma, yes, that is
without any reason.
Yes. Second, but 79 is also important. The magistrate has passed the order. So very surprisingly, my lord, for the same thing, two courts are functioning. I don't know.
This is the order which is under challenge here.
Both the orders, my lord. Please come to page 79.
This is 22/9/2023, and then
this is 2/9/23. This is also on the same day. Two orders passed, my lord. Both are 22/9/23. How? IO's report was
one is by
CGM and another by judicial magistrate first class. Yes, my lord.
And what is that other order says?
It also, please, it is only one page order. Let me read it, my lord.
Yes, please.
Page 79. CR put up today. Case is fixed for IO report for consideration of criminal misapplication number 53 S23 under section 451 456 CRPC filed by the petitioner Sri Vijay Singh.
Just hold on for a minute. This is for criminal application of 53S. 53S of 2023, isn't it?
Yes, that was our application.
Now come to the previous order. Now this refers to some different application number.
That is there.
No, this is 21 filed by Sri Sanjay Sharma and Vijay Singh.
Yes.
So
for both. It was both the petitions were there, yes.
It means there are two applications.
Two applications. When it came up. Yes, because it was not heard, so when the IO report was put up, then we submitted the application for hearing.
No, that is, see, kindly clarify, yes, see. The first order is passed on two applications. This is application number 20 of 2023, that is filed by Sanjay Sharma.
Yes.
And application number 21 of 2023 filed by you.
Yes. Yes.
Now, your application was concerning release for Jimma.
Yes.
Now, how then another application by you comes then?
Because when it comes to judicial magistrate first class, my lord, with the IO report, then again I submitted. Please hear me on the point.
All right. Okay, you filed this thing. Then in such a case, one of the applications should have been withdrawn from one of the things.
But it was disposed of. CGM disposed of the application in the absence of IO's report. So I had to file another application before JMFC.
No, but then one application should have been withdrawn.
No, but it was disposed. Where is the question of withdrawal, my lord? It was disposed of. My application there.
You want to say that both the petitions were taken simultaneously by both two courts. They are proceeding together.
Yes, separately they are on the same day. Two courts sit for the same matter, my lord. One with the IO report, another without IO report.
See, they are represented by one counsel.
Yes.
See, this Srimati M. Shah appeared in both the courts.
We had no other option.
Was it not your duty to inform the court?
Whom?
At least one of the courts. How could you appear before two courts at a time and press?
No, my lord. This is not the case. My lord, the position is like that. First, my application was moved before the judicial magistrate first class.
Where is that? Take us to your application number 21 of 2023. Where is that? We do not know, Mr. Siddiqui. It seems like this, like the strategy adapted there is not very fair. Let us see what happens.
No, my lord, let me explain that position first. I will come to that position.
Just show us the application number 21 of 2023. And then take us to that another application, that 53. We want to see what were filed, on which these applications were filed, and with what prayer.
I think that application is not true.
No, then that will be needed, because we want to see, because we now, the thing has become more suspicious. Yes, Mr. Khera, was it a fact that these two applications were taken up simultaneously on the same day before two different courts?
No, Lordship, how the matter transpired is that, if I may be given 2 minutes of accommodation, Lordship,
yes, just what we want to know.
Lordship,
Just
they
before you place your version, we are just asking you just to seek clarification. Okay, we just right now we do not want that you should start your submission.
Lordship, if we
Now-
see the order, they were taken up on the same day.
Yes.
However,
that is what.
However,
that is
the
what.
order of the JMFC, learned JMFC, we were not party to that petition, but the learned JMFC observes that the learned CGM has disposed of the application. Lordship, page 79,
Okay.
last paragraph,
I'm sorry.
page 79.
We do not know how could this two application be pressed before two different courts. This normally says supposing it may happen because we have many magistrate courts.
Lordship,
Exercising concurrent jurisdiction.
Lordship,
So it may happen one matter lands up to two different.
Lordship.
And when the same sets of counsels are appearing, there is no difficulty to inform the
Lordship,
court
Lordship,
that matter stands seized by CGM and that CGM will.
Lordship, as the fact stands, is that they filed an application for Zimma. We filed a misc application, bringing on record the order passed by Lordship.
It's okay. We'll just let them clarify how they do.
Lordship.
We'll just want to see both the applications.
My lord, this annexure 21, page 59 is the 5323 Jima petition.
Annexure 21, page
59. Little lengthy petition, my lord, but the prayer is that in the premises aforesaid is most respectfully prayed that your honor would be graciously pleased to pass necessary order releasing the said seized articles in the Jimma of the petitioner, and for which act of kindness the petitioner shall ever pray. That is the main application before the Chief Judicial Magistrate.
When did you file this application?
It was filed on 15 September 23.
Where about the other application, that 21?
21 is at annexure 24, page 80.
Yes.
And in this application, only prayer for hearing of the Jimma application being Jimma application number 53 of 23, filed by the petitioner along with the application filed by C. Sanjay Sharma. And this is dated 21st September. Hearing took place on 22nd September. Because it so happened, my first application when I filed my lord 53, on that day, I don't know for any reason, CGM was not there. So it was put up before Judicial Magistrate First Class, my lord. So Judicial Magistrate First Class on that application called for the IU's report. And on 22, IU report was submitted. But CGM took the matter without going through the IU report and passed the order.
Maybe, see, but then the thing is that what we noticed that same counsel appeared.
Yes.
Was it not the duty of the counsel to inform the court? Could the counsel pursue the same thing before two different courts?
But how it was possible? Because CGM disposed of my application.
No, CGM disposed of after the lawyer appeared, isn't it?
Yes.
Then?
But it was not
the
heard.
CGM had not passed any order before the lawyer appeared.
Of course not.
Then?
But my problem is that when the IO report was not put up before CGM, it was put up before GMC. Why? Why this abuse of process of law, my lord?
That because of that you wanted both the courts to pass order.
No.
Just because then the IU report was produced before one court. You see, we do not know what sort of argument you are making.
No, but why
we are asking you how could one counsel pursue application for the same bill before two different courts at a time?
No, not at a time.
Forget about.
No,
it
was
the same date.
On 15
On
September.
the same day,
No,
it is
my
not
lord.
at a time.
It was filed on 15 September, first one. Second one was filed on 21st September.
The order was passed on the same day.
Yes.
Then?
So, because again I was called.
We do not know. You were called, and then was it not your duty to say that this was decided?
Yes, we have
Did
informed.
you say which order was passed?
First CGM.
First CGM. Then in the second order, what was the thing? Did you inform the court that CGM has passed the order?
Yes, that is what the CGM has said, that CGM already passed the order. It is there in the order itself. Please see, my lord. Page 79. It says the order was passed.
Page 79, yes.
Yes, my lord. CR put up today, case is fixed for IO report for consideration of penal miscellaneous application number 53, filed by the petition Sri Vijay Singh for Jimma of bunch of keys, and the weighing machine seized by the police from the petitioner and now lying in the court Malkhana. Srimati Meena Shah, learned counsel for the petitioner, is present. Sri D. Vardiri, learned APP, is absent. Seen and previewed the IO report, wherein the IO has raised objection to the Jimma of the seized article to the petitioner, as the ownership of the seized article is to be ascertained, as there is claim and counterclaim of ownership by the complainant Sri Sanjay Sharma and the petitioner. Learned counsel for the petitioner prays that necessary orders be passed.
Yes.
The
So
petition.
how can he make it this prayer? If at all at that point of time CGM had passed the order, how with prayer may be made?
What? Please let me read further. It has
Is
come.
it not a kind of a contempt on the part of the lawyer?
But it has
Mr.
already
Siddiqui,
said.
think over, Mr. Siddiqui, think over. If you want this court into the depth, then we will go it. You see, you may end up in some more problem. If this is the thing, definitely you will take some action. Because this is, it doesn't seem to be fair. Now it is your own admission that by that time CDM had passed the order.
Yes.
And you tell the court again to pass the order.
No, my lord, because both the orders were passed on the same day. The order was not ready when it was called.
Changing your submission just before, sometimes you say
It was passed by CJM.
that
I agree.
Just before you said that judicial magistrate was informed about the passing of the order by CGM, and that is how it was reflected therein. Now you say that your submission is the prayer necessary orders, past necessary orders. So what you say and what the record says, different things. But in fact, you started this very matter by that way. Initially, you said that you were not hard.
Yes, my lord. That is.
And then this entire record said that you were hard.
No, for in CJS also I was not hard. I said I was present, but I was not hard.
See, please remember, you are senior counsel. The court looks for ahead to you for assistance. We do not know what you are doing.
But my lord, IO's report should not be considered in that case. IO report should not be considered.
Jumping to the merit. First, clarify your why you are trying to shift.
But my lord, but normally in the court, you know, my lordship.
As you have read out the order, in this read out the order, see, subject to what Mr. Khera says, we find that this order, so far as the court, this order of CGM is concerned, perhaps that is not a correct way of, you see, like passing an order in a GMA application. That much is understood. But then there is something else which you are not pointing out. You are trying to basically jump those issues.
But my lord, normally what happens in the court when a matter is heard or considered, then the order is passed solely, and by in the evening we don't get the order, my lord. That is also
then
there.
If you are heard, then you should tell the court. You cannot go and tell the other court to pass a necessary order. So that is, we do not.
But please see, my lord, my petition is on 21st. But please see the petition also. It was not on that day petition was filed. Petition was filed earlier.
We do not know.
It was not on the same day.
Which way was it not the fact that both the orders were passed on the same day?
But
so what petition, whether the date of petition, which way it becomes relevant?
Both the petitions were before two, but it is not my fault. Why it was sent to GMFC with the IO report? It is the CGM should have considered the IO report, my lord.
So you want to say that if you appear on two different courts on the same day, making this kind of submission is not your fault.
My lord, but IO report
of the authority why it was put up before two different benches. All right, no problem.
But my lord, whether the CGM should have considered the IO report or not, that is my. Why it was put up before GMFC? First it went to CGM. CGM passed the order, then GMFC takes the case.
What is the role of the lawyer in the court? In a court of law, you being an officer of court, just tell us what is your role. What is your role? Just tell us.
So, when the
are your duties simply confined to serving the purpose of your client?
No, my lord, I said that I may be heard what was wrong there with based on the IO's report, my lord.
No problem.
Based on the IO's report.
Anyway, this is your submission. We'll pass something. All right.
So, my lord, on the point of the IO's report, nothing will come.
Srimati Meena Shah.
Yes, she is not.
She's not the counsel here.
No.
She's a counsel from Shillong.
Yes. She was the counsel.
Yes.
So, my lord, in that event, there is no.
Complete your reading of page 79.
79.
Yes, that is, we were stuck there at.
Okay.
The Land Council necessary order.
Seen and perused the IO report. Get read.
That come read from below. After the Land Council petitioner praised that the necessary orders be passed. Then the next paragraph.
The petitioner is the named accused in the instant case and is alleged to have committed the offence under section 380 IPC. The petitioner accused has preferred Jumma of the 21 keys seized in the instant case. The complainant Sri Sanjay Sharma White order dated 1/12/22 in Jimma application number 6722 was allowed custody in the set seized 21 members of the key. The petitioner, aggrieved with the order, had approached the Honorable High Court in Criminal Division number 123. The Honorable High Court, by its order dated 15/9/23, had dismissed the Criminal Division number such and such. In view of the order dated 15/9/23 passed by the Honorable High Court in Criminal Division number 123, the order dated 1/12/22 passed by the Learned Judicial Magistrate First Class Shillong in Jimma application number 6722 stands. Also perused the order dated 22/9/23 passed by the Learned CJM along the petitioner number 2023 of the complainant Sri Sanjay Sharma. In view of the order passed by the Honorable High Court in Criminal Division number 123 and the order dated 22/9/23 passed by the Learned CJM, the present petition, that is Jimma 53S23, cannot be considered as such. It is stand rejected and disposed.
So by the time this order was passed, the CGM had passed the order, and that was placed before the order. But even in spite of that, that application was placed. Yes.
But my lord, here at least JMFC is saying that about the IO's report, CGM is silent on that. CGM does not speak anything about the IO's report. There is an objection. Government advocate was also not present at that time.
Could not follow. Please repeat it again.
My lord, I submit that the IO's report was submitted on 21st April. Please see where the last page is IO's report.
Yes.
It was submitted on 29/23.
Yes.
CGM passes an order on 22.
Yes. And what is the IO's report say?
Not to release. Your Honor, last paragraph I am reading. Yes, Your Honor, I must respectfully.
What is the date of the IO's report? Where is this reflected? Where it is
This
reflected? Oh, it's on the top. Yes. 29/2023.
Yes, my lord.
Yes. And then what does it say?
So the last paragraph, my lord. Your Honor, I must respectfully pray before your honorable court that 20 number of keys may not be released on the Jimma to the applicant at this juncture, as ownership of the materials is yet to be ascertained. And also there is claim and contract claim of ownership between the alleged accused Sri Sanjay Singh and the complainant Sri Sanjay Sharma. With regards to the seized material listed in serial number 2 of seizure in Markhana number, and the instant case is pending for further investigation. Had this report considered by the Learned CGM, no order would have been passed in Jimma.
Applicant means whom?
Both
Means
now. Anyway, both. Sanjay
And
Sharma.
then before that, just a minute. Before that, this IO report came on 20th.
20th, yes.
September.
Yes, my lord.
Now, before that, there was an order of Jimma passed.
Not by the CGM. CGM passed the order 22.
And
Right?
whatever in the matter, the order of Jimma was passed, which stood to be challenged before by you in High Court.
No, that was earlier round. Yes.
So,
Yes, my lord.
So, at that point of time, there was no IO report saying that should not be released to any applicant.
No.
But then it comes only after the matter, the High Court vacates the order.
Yes. Because JMFC had called for the IO report. After it went back and we submitted an application for release in our number. But my submission, my lord, what prevented CGM from taking into consideration this IO report? And Learned PP was also not present on that day. It could have been waited
Whether
for.
this IS report will bind CGM?
At least something should be there that I don't agree with the IO's report. It should have been considered, my lord.
If it is ignored, it will be an illegal exercise of jurisdiction.
Then what is the purpose of calling for IO's report, my lord? It serves no purpose.
You are not answering it that way. See, you are the query, you are replying with another query. So anyway, according to you, this IO report was not taken into consideration.
Yes, my lord.
Yes. What else?
That's all.
So this is the only point.
Yes, that it was not considered. Had it been considered, the result would not have been the
That
same.
is the only point raised by you. Nothing else. Yes. This is an application under 482.
453.
397, Lordship.
397. The order passed is revisable. Not appealable order.
No, it is not.
Yes, anything else?
That's all.
Yes. Yes.
May Lordship. Lordship, 2-3 questions of facts have been intermingled. It's my duty to bring the facts.
Definitely, it is your duty to bring the facts.
Lordship, the IO report which has been pointed out by my learned senior sir here,
Yes.
senior counsel here, that has got nothing to do with the order passed by the CGM. Because the CGM never called for any IO report. As is being projected, the question of IO report with regards to the order impugned. If Lordship sees the cause title, before I begin, the cause title does not speak of challenging the order passed by the learned JMFC. The order is only
The order is inconsequential. It has nothing to do.
Lordship, they have only challenged the order passed in their application number 21 of 2023, which they began by saying that they were not heard, but the order speaks otherwise. Now, Lordship, the genesis of this case will be important. It will be important to put forth before your Lordship, so as to adjudicate it. Lordship, my counter affidavit, page 65, annexure 8. Lordship, it is the FIR which I had filed. There is no dispute with me being my ownership is 65, Lordship, annexure 8. It is the reply filed by me, respondent number 2.
Page 65 is page 65.
65, Lordship.
No, it's a continuation of some. This is paragraph 13 of.
I believe Lordship has the revision petition before your Lordship. I'm talking about my reply file to it. I filed a reply to the revision petition, Lordship.
There is a response filed by you.
Lordship.
So your reply is not a part of the revision application.
No, Lordship. I filed a reply to the revision application.
No. This the what you are referring right now. Page
65, Lordship.
65 is what?
FIR.
This is not a part of the revision application.
I believe, Lordship, all the annexures I'm relying upon, some have been placed by them, some have not been placed, and some in parts.
Yes.
Thus, we felt it was necessary to file. If your Lordship is of the opinion, I'll try to take out those documents from their counter affidavit itself, Lordship, from their revision petition itself. May I, Lordship?
Yes, please.
Lordship, we filed this FIR on 10th of October 2022, alleging that the two accused, that is Shri Vijay Singh and his wife, they came, they manipulated the chokidar.
Where is that part?
Lordship, if I may read it, Lordship.
Yes. You do not have a typed copy. This is not very legible. Anyway.
I'm very sorry, Lordship. We'll keep it in mind. May I read it?
Yes, please.
That I am the proprietor of a firm by the name and style of Messrs. Kailash Aluminium and Steel, having its office at Sharma Nivas 13CB, Garikhana, Shillong, dealing in the business and trade of aluminium and allied products, and also deals in supply of such products to various government departments. That on 15th of September 2022, the wife of Shri Vijay Singh, namely Srimati Anita Singh, came to the above mentioned shop and stole a weighing machine from the said shop. That again on 16th September 2022, Shri Vijay Singh came to the shop and manipulated my chokidar into giving him the keys to the shop by taking the name of the police to the effect that the police have asked for it. That I also have CCTV footages to show that the above mentioned actions of Shri Vijay Singh and Srimati Anita Singh, and the same can be furnished before you, good office, if your good office pleases. Lordship, this is with regards to the keys that they had taken. We have the CCTV footages. That Shri Vijay Singh, care of Messrs SS Aluminium and Steel, Muda parking lot, first floor, opposite Kali Mandir, Garikhana, Shillong, East Khasi Hill District, Meghalaya, has time and again created nuisance and disturbances towards me, my family and staff members. But now Shri Vijay Singh and his wife, namely Anita Singh, have gone to the extent of stealing articles from my shop as well as the keys to my shop, thereby committing the offence of theft in a dwelling house place. Therefore, strict action may be taken against. Lordship, this set of keys at page 84.
Of same paper.
Same, Lordship. Page 86 is the type copy, Lordship. If I may, Lordship.
Yes, sir.
Page 86 is the type copy.
Caesar list. Caesar list.
Caesar list, Lordship.
Yes.
Lumdingiri PS case number 123 of 2022 under section 380, Lordship. Lordship, the operative. What? I, Shri Y. Kriyam of Lumdingiri PS, do hereby today, the 29/11/2022, at the above noted place, time seize the below noted items from the possession of Shri Vijay Singh, son of Shri Rajendra Singh, resident of RR Colony, Shillong. The seizure is made in connection with the above referred case in the presence of the below signed witnesses, Lordship. Lordship, name accused in the FIR. Keys are seized from his possession.
There is an allegation of theft on him.
On him.
It's a recovery of the stolen property.
From him, from his possession, Lordship.
So he cannot have a better title than him.
Lordship. Now, Lordship, post this, we filed a Zimma application, Lordship.
He is the accused in the matter.
He's the accused. Keys are recovered. I file a Zimma application, Lordship. Page 88.
Oh, you also filed a Zimma.
Lordship, this is 2022. Bring the genesis of the matter. May I, Lordship?
Yes.
Seen and perused the report from IO SI Y. Kriyam, heard the submission of the learned counsel for the petitioner Shri N. Khera. Having perused the report, seizure list and materials on record, this court finds no impediment in allowing the Zimma articles as per MR number 109 of 2020 to be released on Zimma on the proof of ownership. In view thereof, let the seized articles as per MR number 109 of 2022 in connection with the instant case be released on Zimma to the petitioner on executing a Zimma bond of ₹10,000 on proof of ownership, and on the following conditions: the petitioner shall not sell the seized keys and the weighing machine without the permission of this court. The petitioner shall produce the seized keys and weighing machine as and when required by...
to you on the basis of your application, and at that point of time there was no application.
Nothing. This is 2000.
So why this order was interfered with?
Lordship, they interfered with the order.
This order was interfered with.
They came and then they withdrew.
By the High Court.
Lordship, that was done. They had moved it ex parte, and I'll come to the order, Lordship.
Yes.
So, Lordship, now after this, I produced my proof of ownership before the concerned court,
yes,
and the court granted the Zimma to me. Now, in the meantime, Lordship, page 69 of my reply, I filed a civil suit.
Okay. You filed a civil suit.
I filed a civil suit for a permanent injunction because he was interfering in my property. He was creating nuisance and trouble. So, Lordship, I get an interim order in my favor, page 69, annexure 10, from the court.
Page 69.
The order starts, Lordship, the operative part, we can come to page 76.
Is the party to that?
Yes, Lordship. They have. This was an ex parte order as on date, which I am showing. If I may, Lordship.
Yes, please.
Lordship, page 76, third last paragraph. This court, if I have your Lordship.
Yes.
This court, after careful perusal of the application and hearing the counsel petitioner, and also after considering the fact that none of the parties in the instant case could be prejudiced, is inclined to grant ex parte interim injunction in favor of the petitioner. I am the petitioner, Lordship. The opposite party is hereby restrained from 1. Entering the compound of Shri Sharma Nivas, wherein the petitioner is running his business in the name and style of Kailash Aluminium and Steel, and interfering with the petitioner's business in any manner whatsoever.
He is the opposite party, is it?
He is the opposite party, Lordship. Directing the officer in charge, Lumdingiri PS, to ensure the compliance of this order of this court, as far as other reliefs prayed by the petitioner, the court considers that there is no urgency to grant the same without hearing the opposite party. Hence, the same will be considered after due course of hearing. This order shall remain in force until further orders. Opposite parties are directed to file show cause as to why this ex parte interim injunction order should not be made absolute by this court. Lordship, page 78. Next page, Lordship.
Yes.
Page 79, 3/7/2023.
Yes.
Record put up before me, case is fixed for final order in miss case number 45H of 2022, in which I had received an interim order, Lordship. Heard learned counsel for opposite parties, Shri Vijay Singh and Srimati Anita Singh, advocate Srimati M.K. Shah. Same advocate who appeared for Zimmer, and she is also on record in this revision petition also, Lordship. Now, Lordship, the operative part, page 82 of this order. May I, Lordship? Hence, in consideration of the submissions of the learned counsels and on the observations made above, this court is of the view that there exists a prima facie case for trial in favor of the petitioner. Hence, the plea of the opposite party is rejected. Ex parte ad interim order granted in favor of the petitioner on 28/11/2022 is hereby made absolute. Instant petition is hereby allowed and disposed of. This stands. There is
Then what remains then in this matter then? Yes, Mr. Siddiqui, what remains? Have you challenged this order? Have you challenged this order which has been read out just now?
No.
Then what remains? What is the right of your person asking Jimma?
My lord,
Civil code has changed.
because he has gone through all these papers, I may be allowed to.
Interim order was passed. Just listen to me. Please, interim order was passed.
Yes.
The order was forwarded to the officer in charge for compliance. You challenged this order, and your challenge was rejected. So what remains?
No,
Nothing remains.
No, my lord, injunction order was not challenged by me.
This civil court's order has not been challenged by
No,
you.
no, my lord. I have not challenged.
No, this order which has been read out just now.
Yes.
They have filed an FAO against it, but in my injunction stands.
There is no interim order.
No order.
So then what things is
But only
remains?
on 2 points I may be allowed to make message. Only 2 points, my lord. He said that Kailash Aluminium is being run by.
Where is it? One second. Just where is that FAO thing? What is that number of that FAO?
Lordship, the FAO which they have filed,
Yes.
that's not part of the records anywhere which...
Any number, anything? And no interim order passed.
Nothing, no pass.
All right. That is correct. Is that correct that you
Yes.
do not have it?
Yes.
I can file an affidavit to the effect also, Lordship.
No, well, it was.
So as of now, what relief you can expect from criminal court?
But
The law is well settled in this regard.
But only
Or you
one-
would like to dispute that?
I may be allowed to point out only 2 points.
Yes, please.
Well, my lord, please come page 24 at lecture.
Page 24 of?
This petition, my petition, my lord. Lecture 13, my lord. 13. Page 24, my lord.
Yes.
This is a certificate under section 22 of the Meghalaya Value Added Tax. It says that name of the dealer is Vijay Kumar Singh and the business is SS Aluminum and Steel House. Father's name is Rajendra Prasad, my lord. So,
Now the thing is that, Mr. Sindhigi, if you want us to record any finding on the basis of this,
no, on this point there cannot be any finding before your lordship. That is why I did not go into all those details. I came only to the point of the seizure that IU's report was not taken into consideration because these points are already in the session
so,
of
but then the thing is that once matter stands seized by civil court, we cannot direct criminal court to review it. So it will be purpose. This order cannot be implemented. You know the position of it. Now you have to get it settled in the civil suit. Nothing remains. Actually, this petition has become infructuous.
So this petition was filed after civil court's order.
Whatever it is, now with the passing of the civil court's order, in this kind of matters, the civil court order stands as a superior pedestal. There's nothing remains.
So let's see how to be passed.
Now, the problem is that you see, Mr. Siddiqui, that all those things, like basically which was earlier pointed out, there is some duty expected by you do not mean you personally, whoever is deputed by you, to point out before the court that this thing happens. If once one court passes an order then there is no requirement of telling other court to pass necessary order in this regard. It is this simple thing. Today, if this, say supposing in this matter, if there stands any other order passed by any other court, will you pursue this application? Your first submission will be that yes, matters stood seized by somebody or the order has been.
But here, what happened, my lord? IU report was not seized before CGM, so that was the only point before the GM.
What? You are a lawyer. See, you are not. You are this thing. You are officer of the court. That is your duty to inform the court.
But
Is it not your duty that see that order has been passed by so and so?
it was placed before the GM of Chelsea. That is why the GM
How can you still make a prayer for passing of necessary order again? Simply you should say that you cannot take up.
May continue.
What more do you need? This civil court's order covers up your thing. What more do you want to get?
Lordship, the confusion with regards to the IO report, because if that has been,
we are not going into all those things.
Lordship.
See, we are sitting in a revisional jurisdiction.
Lordship.
Unlike an appellate court, will not enter into merits.
Lordship.
Revisional court will be just confining to the nature of exercise of jurisdiction.
Lordship.
Now the fact remains, even if IO report says something,
Lordship.
that may not bind the trial court.
Lordship.
One fact maintains what he says, that was not taken at all taken into consideration.
Because Lordship, this learned CGM never called for the IO. This is where they are trying to
see, without calling, if that report exists in the record, then this is the duty of the court to look at it.
Lordship.
Anyway, see, there is no use of going into all those things right now. Since once there is a civil court things, we are not passing any detail order. We'll just say that it appears that concerning the same subject matter, there appears to be an interim order passed by civil court, which is subsisting. So in that view of the matter, this has become there is no other. And we kindly tell associates to be more careful in this kind of things. It's not a very pleasant thing to see, you see. And when you stand as a senior counsel, this court expects you to be very fair. Not to the extent, we're not telling you that go and admit the case against you. We're not saying that. At least whatever the records is. You say nobody, you have not been hard, nobody. See, the records is totally otherwise. And the judicial order cannot be refuted. If you say that your appearance has been wrongly recorded, you should go and present yourself before that court. If there is any mistake, by mistake record your thing. Or otherwise you should be properly briefed also. Sometimes you enter the courtroom without preparation and then you'll end up in this kind of trouble. You are a very senior man. This court holds high regard on you. Yes, hard, Mr. Yes, deal under senior counsel, appearing for the petitioner, and also Mr.
Respondent number 2, Lordship.
Who is appearing for the state? Yes, what do you say? You are supporting the case of which party? Why you are sitting silent? You should say something.
The conducting counsel in Mr. Shibashik said, and the state really does not have much to stand.
Why? This is seizure by the state. There is a IU report prepared by the state, which is made the basis of argument. And on the top of that, the two courts of path order was entertaining the matter at the same time. How could it happen at the time when the state is present?
What I heard was that the state was not present.
That exonerates you. Yes.
I don't have the file.
Yes, hard. So we should not record your name. We would say the state is absent. Shall we record it that way? You want it to be recorded that way? Anyway, yes, all right. Hard, Mr. Siddiq, Honest Senior Counsel, assisted by for the petitioner, MS so Learned Counsel acting for the respondent number 1, and Mr. Khera, Learned Counsel acting for the respondent number 2. By this stuff in the paragraph, by this revision, by this criminal revision petition, the petitioner has challenged the order dated 22/9/2023 passed in, it is called other application. Yes, ma'am. Other application, you just see from this OTH here, you can see at page 19 in the prayer. Okay. Other application number 21/2023 by the learned Chief Judicial Magistrate at Shillong, whereby possession of what is that seizure list? It was at page.
Lordship, in their civil revision, the seizure list is at page number. Lordship would like to refer through their petition itself.
For anything, anywhere it is.
There it's 45, Lordship.
After all, it's the same document.
It's the same.
Yes. Yes, all right. Thank you.
Annexure 15A.
Yes, this is handwritten one.
Handwritten,
Yes,
the type copy
yes,
is there.
Yes, all right. Now there was one weighing machine also which was seized. They are not claiming that.
No, we are claiming both.
What you said? Seized. What the possession of one weighing machine and 21 number of keys which were seized by seizure report dated 29/11/2022. Come on. Where released on Jimma with the respondent number 2. Paragraph. So, the learned senior counsel applying for the petitioner has drawn attention of this court to a report dated 29/2023 submitted by the IO you have to reflect the criminal case number, the seizure made by seizure memo number dated so and so is given in so and so.
Lumdingiri PS case number 123/10 of 2022 under section 380 IPC.
Yeah, this will come. If there is any gap and all, just arrange it. Any confusion, ask. Yes. What you said, the another referred to last time. To a letter, to a forwarding report, or what is that? Oh, what report dated 29/2023 of the Lumdingiri case number 123 within bracket 10 of 2022 under section 380 IPC. Whereby a request was made to the court not to release on Jimma any of the materials seized by the seizure memo dated 1911 feature of the we verify it from the after part. You said Mr. Singh, senior counsel, what you said just first starting of the line? Okay, we'll come below. Then continue and submitted that the learned CGM while passing the impugned order has not even taken into consideration the aforesaid report and directed the release of the seized material to the respondent number 2 mechanically without any application. That is the only ground you have raised.
Yes.
It is a submission of the learned senior counsel. That the learned CGM could not have passed the impugned order. As the trial court has to release seized material on Jimma to appropriate person on the basis of the materials on record. He thus prays that the impugned order be set aside and matter be remanded back for passing of order afresh. What shall we write? The state submission? Yes. MS Sham granted GA paying for the state. Suppose the impugned order and submits. You do not have any these things. You are supporting the order, isn't it? Yes. So only an order and submits that no illegality or illegality has been committed by the learned CGM while passing the impugned order, and there is and the same calls for no interference by the state. Mr. Kerala Learned Counsel for the opinion of the number 2. Refuted by submission. Refuted submission made by the made on behalf of the petitioner, and submitted that the entire seizure was made consequent to registration of a case on the basis of the FIR lodged by him, wherein the petitioner number 1 is the main accused. He further submits that the respondent number 2 is the rightful person to whom the materials were released on Jimna. In support of his argument, he has drawn attention of this court the order dated 28/11/2022. No, we just say in support of his say in support of his interpretation, the Honourable Council submits that a civil suit is pending between the respondent number 2 and the petitioner
So 23H of 22.
that is a miscase of 45H.
Miscase is 45H. In the parent suit is 23H of 22.
What you said? He on the issue of covering the issue of claim and ownership about the materials which are seized by the police. He entitles it number 23H of 2022, pending the court of the Assistant District Judge, Shillong.
Assistant district.
Yes, pending in the court of the Assistant District Judge. Yes. Shillong. Stop. The Learned Counsel further draws attention of this court to order dated 28/11/2022 and order dated 3/7/2023. First, in the above civil proceedings, whereby the civil court has granted an injunction in favor of the respondent number 2. It is submitted that the respondent petitioner is actively contesting the said civil proceeding. And has already filed an appeal against the order dated 28/11/2022 and 3/7/2023. However, has not been able to obtain any order in his favor. The Learned Counsel submits that once the matter stands seized by a civil court and there exists an order in favor of son number 2. The order pass in Jimma, order on Jimma passed by this decision would be dependent on the orders of the civil court, and hence no order is called for, and no order is required to be passed by this court at this stage. He further contends that there is no merit in the claim of the petitioner in this review petition, and revision petition deserves to be dismissed forthwith. Stop. Paragraph. Upon hearing the Learned Counsel of the rival parties and on perusal of materials of record, it is clear that there is a civil suit pending covering the subject matter which were seized in connection with such and such police case number. Stop. There are also order passed there are also interim order passed in favor of the restaurant number 2 and direction has been made to the police authority seeking compliance of the interim orders. Stop. Since the entire matter stands seized by civil court, insofar as the claim and ownership of the seized material is concerned, no purpose would be served by entertaining this revision application. Furthermore, the petitioner has also been, petitioners has also not been pointed out. In any glaring illegality in the passing of the impugned order dated so and so by the learned Chief Judicial Magistrate. The contention of not taking into consideration the IO's report dated 29/2023 cannot be a ground for interference in this review application, as the same has not led to exercise of any improper exercise, same has led to any improper exercise of jurisdiction by the learned civil. In view of what has been discussed above, there is no merit in this revision application and the same stands dismissed. Yes.
Item number 12.
Today I catch hold of my learned friend.
Yes.
My lord, basically, my lord, some questions which I have framed, my lord. Number one, whether, my lord, ingredients of section 192 of Motor Vehicle Acts,
This is
quashing of FIR,
oh yes,
my lord, that DGP matter.
Yes, yes.
So whether, my lord, I am before coming to the, my lord, judgment and all, whether, my lord, ingredients of section 192 of Motor Vehicle Acts are attracted against the petitioner, number one. Number two, your lordship, whether before registration of FIR, whether the police authority has ascertained that cognizable offence has been made out, or whether any preliminary inquiry which is required to be done as per Lalita Kumari judgment has been done or not. Number three, your lordship, whether the FIR was lodged with malafide intention without considering the law laid down by Honorable Apex Court in Bhajanlal, where it says police cannot investigate where the non-cognizable offence are made out without permission of settled law, under subsection 2 of section 155.
So 192 is non-cognizable.
Non-cognizable, my lord. It can be investigated with the permission of magistrate. Because, my lord, no offence was made out on the face of FIR, police registered FIR with malafide intention without conducting any preliminary inquiry to find out whether FIR discloses cognizable offence or not.
What is the requirement of preliminary inquiry?
My lord, that Lalita Kumari judgment, your lordship.
Now, is it mandatory on
my lord in
the
the
part of the
present
police
case, my lord,
to go for preliminary
my
inquiry
lord,
in each and every case?
no, my lord, not if there is a delay. If FIR has been lodged,
so here, when the cause of action arose and when the FIR
my lord, I joined in the year 2022. FIR was lodged in the year 2024, my lord, in the month of May.
No, from when you started using that vehicle?
My lord, when I joined here, my lord.
Now, before that, before you come to Lolita Kumari,
My lord.
just clarify on certain points.
My lord.
Now, when a department uses a seized vehicle,
my lord.
Or sorry, requisition.
Requisition vehicle.
Not seized vehicle. A vehicle which is requisition for the purpose of official use.
My lord.
Now, who makes the allotment of those vehicles?
Government.
To be used by a particular officer.
Government, my lord.
Is it by the official who uses it?
No, my lord.
Or is it by somebody else?
By government, and maintenance
Now,
has.
tell us in DGP's case, here in this instant case, the vehicle where it is alleged that the number was changed and which was used by him. Now, who allotted that vehicle to be ordered by DGP? To be used by the DGP?
My lord, government, my lord, government of
Who is the official?
My lord.
Who is the official? Let us simplify it. We may not go into all those things.
And
if DGP doesn't have any hand
true, your lordship,
in use an allotment of his own vehicle,
my lord,
so you cannot be held liable.
Exactly, my lord.
So even if if there stands any FIR against him,
my lord,
that will not implicate him, cannot implicate. So if you can show that, then we can make things simpler.
True, your lordship.
And if you can be more specific by showing that there exists any order, departmental order,
my lord, there is an order,
which basically says that such and such vehicle should be used by DGP.
My lord.
If lordship have that final report, your lordship, at paragraph 5, your lordship, that will reveal everything, your lordship.
In the report is also there.
Have you submitted a final report to us?
Lordship, yes.
Yes, my lord.
Yes,
Given, my lord, this is letter issued by government, my lord.
That is not a part of your petition.
My lord, I have mentioned, my lord, that it was
That is
requested.
government letter. So admissible in evidence, isn't it?
My lord, in fact, I mentioned it, my lord.
Yes, Mr. Shulai, which part you are trying to point out?
Come to page 5, or paragraph 5 of the report.
What is that page?
Page 7, your lordship.
Yes.
Investigation revealed that on joining of Shri So-and-so IPS and Meghalaya Police, he intended to use the opposite Kia Carnival limousine vehicle. Accordingly, the government of Meghalaya Transport Department, it was the Transport Department, your lordship, accorded and has conveyed its approval for usage of the said vehicle on so-and-so at the rate so-and-so per day and night so-and-so, with the condition that the officer shall use the private vehicle bearing registration number so-and-so under Meghalaya registration, and not any MLO2 registered vehicle.
Officer shall use the private vehicle bearing registration number so and so.
That permission
under
is
Meghalaya reservation and not any ML02?
Yes, that means he can use that vehicle but not under the MLO2 registration.
Regarding section 14 of our Meghalaya Police Act, my lord, because I was at that time, my lord, Z category security was given to me, my lord. So maintenance of my vehicle, my lord, security, everything, it is with SB branch, and vehicle has been maintained by.
Who ordered the change of these things?
There was, in fact, because of the internal report, my lord, because I have to move.
Wait. If there is an internal report,
my lord, that is.
There has to be some sort of communication,
my lord,
isn't it?
General order is there, but internal there was communication because of that, my lord, because Assam number was there. It is not for regular basis, your lordship. If visiting,
let this document which he has relied lordship be given to me.
I am giving. Yes. On the last occasion also.
Just take me by surprise, lordship.
Yes.
No.
Mr. Shulai, if required, you will take instruction.
But it is a general letter, but internal letter, it was instructed by SB branch to MT branch. And MT branch is doing, my lord. This DGP is not doing. Which vehicle DGP will sit, what should be the number, it is not my duty, my lord. It is the MT branch. A specific branch is there.
That is. This is official communication.
My lord, this is in general. DIG. And some instances where also some vehicles have been, my lord.
Which part you want to?
In the last, your lordship will find that not to use Assam number plate. Thereafter, internal advice, my lord. There was. It is in general nature, your lordship.
Yes.
But internal report was also there. If I am going to some, my lord, sensitive place, my lord, because of that security, SB branch instruct MT branch, and it is by way of, it is not in general use, your lordship. Because I was holding that position, so there was live threat. And the person, my lord, who has lodged FIR, he was, my lord, charge sheeted in 11, more than 10 to 11 cases, your lordship. And my lord,
That is all right. We are
my
coming
lord,
to, let us not jump.
my
Let us
lord,
just
my lord,
first
my
try
lord,
to settle something.
my lord.
See,
Otherwise also 192, it is not attracted, even assuming for the sake of argument.
yes, definitely will be on the points of law, is
My
it?
lord, definitely.
We are keeping everything open, but then
My-
we are just trying to ascertain the past, the actual whether any responsibility can be fixed on DGP. Say today, I am entitled with official vehicle.
Z category, your lordship.
Whatever I do not know, but then see where from that vehicle came, who has allotted the number plate. I am totally ignorant.
This
Now
is the,
tomorrow, if you catch me and say that I am using a false number plate, I do not.
this is the same thing, same thing with DGP, my lord.
So that is what the thing. So that is why I am just trying to see, like ascertain.
Two vehicle, sometime different vehicle.
How the
was,
system works.
my lord. Sometime different vehicle is given, my lord. In the convey, my lord, not only my vehicle, so many vehicles. If required, my lord, I may change vehicle also, as per the situation demand, my lord. I don't know, my lord. My pilot escort number, my lord. If they are also going, what are the number they are using? Also, I don't know, my lord. And by using that number plate, no advantage, nothing I have taken. Not for the sake of pleasure, my lord, I was using.
Now, this is one thing which you have given as
My lord,
now this communication.
my lord.
That is in 2022.
22.
But then says this, if you see this transport department approval is subsequent, isn't it?
My lord, thereafter, my lord, vehicle goes to empty branch.
This 22, your lordship, in my understanding, will not be applicable in this case. This is will be it's general only. It's general, your lordship.
But internally,
If it is general also, it can be implemented, isn't it?
General means to say, your lordship, so it is applicable to commercial vehicles and mostly commercial vehicles, your lordship. Because going by the what has been said in the letter, your lordship, the law and order situation is so.
No, but then it speaks about Assam registration, doesn't say commercial or private.
nothing is there, my lord.
Mostly commercial, your lordship.
So which way we will classify that?
But this is only before that, not after.
Exactly before that.
Not after this.
Because your final report, it refers to this thing, the order of the transport department dated 1/8/2020. So much after this.
Yes.
Thereafter, my lord, in the report also, when it was used, there is no details, my lord. Sometimes it happens, but I am not responsible for that. Otherwise, also 192 says, my lord, it says about without registration. It doesn't say about different registration.
Yes,
My lord.
You've seen the last paragraph of the page 7 of this report.
My lord.
Now it says that this ML02 number,
My lord.
which you were using, was basically meant for a Hyundai Verna vehicle.
DGP. That vehicle is meant for DGP.
See, it says this be against Hyundai Verna vehicle.
Against that Hyundai Verna, my lord.
And not against the vehicle which you were using.
My lord. This Honda Verna, my lord, it was allotted to DGP.
That is all right.
My lord.
But then, see, we are concerned with the change of number from one vehicle to another.
Different.
Okay, we see here the DGP things be very important. See, because both the vehicle were meant for DGP use.
True, your
So it doesn't mean that you can interchange.
Whether I am responsible for that.
That is
that,
exact. That is exact.
And the section which they have.
Now even their charge sheet order doesn't say it was done at the instance of the judge. Now who did it?
Empty branch, my lord.
Even in paragraph 6, you see.
It is quoted, my lord, regarding, my lord, one judgment. It is a part of judgment, your lordship. Para 6. State of Maharashtra. They have relied that judgment also I have, my lord.
Which paragraph 6?
Para 6, which your lordship, page 9 of report, my police report.
Yes.
This is not in respect of me, my lord. Similar issue came up before Honorable Bombay High Court.
We are not on that. No, we are not on that. We are on page 7 and 8.
7 and 8.
There is another paragraph 6 at
My lord.
para 8.
Yes. Investigation revealed that.
Changing the registration number. No, that is it.
Investigation revealed that Sri so-and-so, while working in the capacity so-and-so, has indeed used the vehicle so-and-so, changing the registration number. But who has changed? It is not clear, my lord.
Yes.
Lalita Kumari, your lordship, may kindly see. Because all the offences
Now,
are not.
Your first contention is delayed FIR.
My lord.
Could not have been acted upon without any preliminary.
My lord.
Now, when this vehicle came to be used by the
in 2022.
No, but then
Order came later, my lord. It is written post. The lordship will see the order. Post sanction was given, your lordship. And I have given my lord.
What is the order means? Which order?
Official.
These are not part of records.
Requisition letter, but I have mentioned everything, your lordship.
Please, if you rely on something, please give it their advance copy. That is something very unclear. You may have to take instruction also.
My lord.
If you place reliance on those.
This is the requisition, my lord. Later it is.
File a buy-in affidavit, your lordship. Bring all this, whatever he wants.
He can give you advance copy of the things also.
Yeah. Whatever he wants to rely and give your lordship, let him file an affidavit with an advance copy to me, so that if necessary, I'll call the investigating officer, your lordship. Because the investigating officer, your lordship,
If you carry on this way, then it is difficult for the court.
your lordship.
Next week, your lordship, or any day.
We do not know. See, as the winter approaches, because very soon the holiday will. You have internal protection with you, so that is what you see.
They'll come after vacation, your lordship. Since like there is a
all cases we cannot dispose of.
True, your lordship. True.
So you have to pass judgment. If we hear it and if you do not pass the judgment, that also becomes useless. And then you have to come back again. You have to again refresh the.
My lord.
Okay. Third, Lance Council, applying for the parties. The Lance Council for the petitioner while arguing the matter has sought to rely on some additional documents which are not part of the record. Mr. Shulai, has expressed his difficulty to argue the matter in absence of advance supply of the documents, additional documents which are sought to be relied upon by the Learned Counsel. The petitioner shall, in view of the above, the petitioner shall. What shall we say? So we will file an
Additional affidavit. Additional.
The petitioner shall file an additional affidavit, bringing on record the additional documents sought to be relied upon by the petitioner. This is better after 2 weeks.
Let come after vacation, Your Lordship.
It's as agreed for by the parties. This is matter after vacation.
Deeply obliged.
Instead of, probably issue may not be very huge here.
My lord.
Instead of making very these things, probably you can cut short it. Just think over.
My lord. Why I am submitting, my lord, that because police cannot register FIR mechanically, my lord. Lot of
exactly. And then another aspect, if it is the violation of MB Act, the right of a private individual to file an FIR to the man. We do not know whether that will be these things, but it's a mere assumption. And then
that's some guideline.
The duty which should have been, you see, like done by the enforcing agency. Whether
that is also
that is what.
That's why, my lord, subsection 2 of section 155 says, my lord, with the permission of magistrate, only to attract, my lord, that not cognizable offence, section of cognizable offence has been leveled. Subsequently, they themselves saying that no offence has been made out. But why I am saying so? So their, my lord, malafidness, my lord. Only for the purpose of registering FIR.
That is definitely one of the aspects.
My lord, my lord, being a head of, my lord, police, so much embarrassment I have to face.
Even if, say, supposing, if any FIR is filed with malafide intention,
my lord,
and while investigating, some genuine case comes up against you,
my lord,
can we say that just because the FIR was filed malafide, this will be ground for coercion?
That's why I am saying what I am saying. If the preliminary inquiry ought to have been conducted, my lord, then they will not go that whether offence has been made out or not. That's why Lalita Kumari has, my lord, laid down the law.
That is what you are saying. We'll just examine that.
My lord, we'll file.
If you say that the delay means, what is delay?
Delay of 3 months from the date of cause of action, then preliminary inquiry should be done as held by Constitution Bench of Honorable Apex.
Okay, so cause of action for whom?
My lord,
state or for the informant?
My lord, because
now, if you see here, the informant has filed this FIR
in 2014.
Consequent upon obtaining information under RTI, probably. Is that correct?
My lord, he was working with me, my lord. He was, my lord, my ASI subordinate.
See, for technical reason, which you will compute this cause of action, that is also a question.
My lord, because the number.
Please, you have to, you see, assist the
I will, in the affidavit, I will give detail, my lord, date and all.
This court has the habit of going deep into it.
Very, my lord.
So
I would like to.
Where you start and where you end up, we do not.
My lord, I will give it details, my lord, so that.
Sometimes you may find that we are asking irrelevant questions. But then,
my lord. But my lord, for the sake of, my lord, clarification and all, unless until your lordship is not satisfied, how I can, my lord, I have to satisfy, my lord, that whatever has been done, it is not done in bona fide way.
That is all right. But then, even if we assume that what you say you are correct, that the private respondent is the malafide intention.
And police.
Then, how can you? All right.
Because police has registered, my lord.
But then what happens if we find that prima facie there appears to be a good case against?
Then in that case, I have nothing to say, my lord.
So
that's your lordship.
You have a,
my lord, that's why they themselves admitting that no cognizance.
That is why, you see, your duty is not confined only to establishing the malafide of the parties. You have to rely on other aspects.
Why I am saying so, it is corroborated, my statement is corroborated with their police report, where they say no offence has been made out, section 192. They themselves saying, my lord. That's why I am saying, your lordship. My lord, they have been exposed, my lord.
192 fixes responsibility on whom? The user of a vehicle,
My lord,
or the driver of a vehicle, or the owner of a vehicle?
Your lordship,
my lord, neither I am user,
in conjunction
neither I am
with
owner.
section 39 of the Motor Vehicle Act.
Please explain it to us.
Lordship.
Deeply obliged.